My name is Dillard, and I'm a visiting scholar with the Vulnerability and Human Condition Initiative here at Emory University School of Law. I'm also Director of Litigation at the Animal Legal Defense Fund, nonprofit based in California that works towards advancing the rights of animals. I was always interested in the protection of animals, but it wasn't until I practiced for some time that I realized that where animals fit into our legal system really makes no sense. They're considered the property of persons, and that's not how we ethically or morally regard them. The law is just lagging really centuries behind. So I became interested in trying to change that, and after practicing with the Department of Justice for several years, started working in animal law. I didn't get interested in reproductive rights until I'd been practicing with the Department of Justice for some time. I was assigned a case involving the deportation of a family from the People's Republic of China. And they resisted deportation, claiming that they qualified for asylum because they had had 3 children in violation of China's one-child policy, and they would be persecuted for that when they returned. And I became interested in the issue because at the time, Congress had changed the law to say that any resistance to the one-child policy constituted political grounds to claim political persecution. And the basis for that was the argument that China's one-child policy itself, not its enforcement mechanisms, the awful enforcement mechanisms that you hear about, forced abortion, forced sterilization, but actually the policy itself that people should only have one child, that violated international human law. And there was really no basis for that argument. It was just something Congress said. So I became interested in that and in animal law at the same time. I'm not the first one to make that comparison, really. Joel Feinberg wrote a paper many years ago comparing future persons' position in the law. So the children that we haven't had yet, but that we will have, and animals. He compared them in the law and noticed that they were 2 uniquely vulnerable classes of persons. I really see 2 connections. One, having children, that's something that matters for animals, really for 2 reasons. One, it matters because those humans that we have will interact with the animals in very important ways. They'll eat them, wear them, experiment upon them, in some cases torture them, in some cases care for them, and in some cases leave them alone. And so really the humans that enter the world are of significant interest to animals. Secondly, you can take the average way that a human treats animals and just multiply that by the number of humans that will enter the world, and you get an idea of what how animals' lives will be vis-a-vis human treatment. So it's really of interest to animals, and in some ways, it's of more interest to animals than laws that are on the books to protect animals, many of which a lot of people have no idea exist. And even if they do know that these laws exist, they have no intention of complying with them, and there's very little chance that the state will ever enforce those laws. So really, whether or not we're making people that are going to treat animals well, that is truly of interest to anyone that cares about animal welfare. I made the comparison, I think, before to say the law is sort of like a key, and the persons to whom it is addressed are like locks. And if you're studying the law of a particular sort of law, like animal law, sort of studying the keys, that really doesn't make much sense if you're not also studying the locks to which those keys apply or are used with. So I think it makes sense if you're studying a particular area of the law that wants to help a vulnerable population, you understand something about the creation of the population that's going to impact the vulnerable population. So I think the 2 are related in that sense, and also in the sense that animals are so different from us that it's difficult to empathize with them, right? It's easy to empathize with your children because they're so similar to you, and many people consider them part of them, really a reflection of themselves. Their neighbors, a little less so. Perhaps persons of other races, even less so. Persons of other genders, sexual orientation, nationalities, less so. We get these concentric circles of empathy. Animals or other species are on the outer orbit, really, and they're very difficult to empathize with. So are future persons. So are the notion that I'm going to have a child in a particular circumstance, you're going to affect a person way into the future. That's not easy for us to conceptualize psychologically. So in that sense, future persons, children that we could have in any sort of circumstances, abusive homes, unfit homes, without any resources, and animals, because they really are defenseless. Those are comparable and extremely vulnerable populations. So on those two bases, I think they're comparable. I really, and I have to credit Professor David Biederman and Professor Johann von der Pfeiffer, their vision of international human rights really made me believe that there are objective values that can underlie law and assertions of human rights. Things that are right, whether or not anyone believes them. Right? So this is very counter the majoritarian idea of law, that law is just simply whatever the majority of the people say it is. And that notion that there are objective values underlies, in my opinion, animal rights. And it also underlies claims that future persons or the children that we have or will have claims to particular rights or values. And that regardless of whatever the majority thinks, those claims are correct and they're true. Yeah. I think because animals and future persons or prospective children represent particularly vulnerable populations, thinking generally about the law in terms of vulnerability makes a lot of sense to me. And it also provides a basis to argue that we ought to provide animals and future persons with protections that they currently don't have. It's already had a tremendous impact on family law, and I think the best way to describe it is it's giving persons the opportunity to really have children when, where, how, and why they choose to have them. So it's giving them tremendous choice over having children. And the law has also changed, moving away from one mother, one father model, consistent with that change in technology. The problem is that the more choice we give to parents over when, where, how, why to have children, the more we're making invisible, really, the interests of the child they will have. If the parent has exclusive authority, entirely theirs to say the conditions that the child will be born into, that really is tantamount to giving them a property or an exclusive use and control interest over that future person. But that future person still has moral and legal interests. So that creates a problem. It creates a property relationship that really our Constitution abhors. The way to break that is to say, despite the advent of this new technology and the opportunity to have non-traditional families, the most important thing about family law is that those future children are given the resources that they, as really as legal persons and moral persons, deserve, regardless of the interests of the parents. And to say that it's not a private matter when, where, how, and why you bring a child into the world. It's very much a public matter, and the way to ensure that the future child's interests are met really is by ensuring that they meet some minimum threshold of well-being. They're given a minimum threshold of resources and an environment that we can agree fulfills their objective right, the rights of the child. And I think there are two good starting points. One is simply fitness as it's defined under state family law. And I think a more hopeful benchmark will probably be the Convention on the Rights of the Child, ensuring that every child born is guaranteed those conditions and that it's not a parent's private choice to deny them those conditions. They really are, despite there's really no debate among ethicists and moral theorists that future persons or prospective children have claims to particular conditions, that they have rights. But legally, they're absolutely invisible. And there's a line of cases that makes that very clear. There are situations in which families, particular parents, have been adjudged to be unfit by a court, in some cases because they abused children that they had. And the children that they had, whom they abused, are now in state custody. They were taken away from the parents. When that happens, sometimes courts will say, I'm going to order as a condition of your probation that you not have any more children until you take this anger management course or you fulfill certain requirements. Then sometimes those conditions end up on appeal and the courts are determining whether or not they're constitutional. Some courts have said they're unconstitutional. What they're saying in effect is you can bring the child into an unfit home. When that happens, because the parents have been adjudged unfit because they were abusive, the state immediately seizes the child, takes them into state custody. So what they've said is you cannot have a living child in an unfit home, but you can place a future child there. And so it really makes no sense at all in that sense. And I think seeing that future children have rights will let courts understand that, in fact, you cannot place a child into an environment where existing children legally are not permitted. I'm going to return to the Animal Legal Defense Fund, and we have a growing litigation division there where we file lawsuits essentially trying to change animal status as property under the law and to ensure that they're treated with a minimum level of humaneness and dignity. Thank you.